on today's version of Nobody Asked Me, but I'm here to talk about it anyway. NBC News reports what Chadwick Boseman and Malcolm-Jamal Warner estate disputes reveal about planning for death. In the subheadline, estate planners say two high-profile legal battles highlight common mistakes that fuel family conflict after death. The Los Angeles Times. Chadwick Boseman's brothers asked the court to oust the widow as the estate administrator. Why? Because she cannot be trusted. Ain't that some stuff? Lots of you, some of you, at least one of you, have been to one of my conferences in the past and heard me talk about Mr. Boseman's estate. You know what? I relied on a news article and did not go do my own research at the time. I should have done better. Mr. Boseman did in fact die without a will. I wish somebody had introduced him to me before that happened, because his family probably could have saved lots and lots of trouble, court costs, legal fees, newspaper reports, all of the things. Disclaimer, everything I talk about, I'm going to be talking about under the laws of the state of Tennessee, despite the fact that Mr. Boseman and Mr. Warner had cases in California. Mr. Warner also had a separate but related case in Georgia. I digress. Talking about Tennessee law, talking about Texas law to the extent that we can work that in there, and Michigan law, because that's where I'm licensed, not in California, not in Georgia. So let's not get that twisted. So as we know, Mr. Boseman died without a will. Ultimately, we thought that case was resolved. It seems in California that when you die without a will, under the default rules, the spouse, and in Mr. Boseman's case, because they didn't have children, the spouse and the parents shared. Now in Tennessee, the spouse would have taken it all. But in California, apparently, you get to share with the parents of the decedent as well as the spouse. That case went all the way through. It was finito, finished, or so we thought. When you go through probate, one part of the probate case is about understanding exactly what the decedent's estate is composed of. And so when that decedent's estate was figured out, everybody knew what their respective shares were supposed to be. Well, guess what? Chadwick Boseman's brothers, on behalf of his parents are the people who actually inherited his 25% each. So it was 50-50 between the parents and the spouse. And so the brothers, apparently, I don't know, at the parents' behest or on behalf of the parents, have come now and said, wait 1 minute. Our parents did not get what the court said that they were supposed to get. And so ultimately, they filed a petition with the probate court for show cause regarding contempt against Miss Ledward. I guess that's how you pronounce her last name. She was the personal representative for the estate. She was ordered by the estate to pay out the respective shares to all parties as determined by the court. It's not a suggestion. It's an order. That's what you're supposed to do. And when people don't do what they're supposed to do under orders, what do? You go back to the court and you complain. Hey, court, you ordered Miss Ledward to pay my parents this amount of money, and at this point in time, she hadn't done exactly that. And so we're here to ask you to enforce your order. Ultimately, the court will land on a resolution in this case. I would imagine the court's just going to ask Miss Ledward a few questions. Hey, ma'am, did you pass out whatever it is that she was supposed to pass out? And either she's going to have the proof that says she did, or she won't, and ultimately she will. So at my practice, what I do is tax, estate, and probate work. And the estate and probate work are very related in that in probate cases, I get to see lots of stuff that has gone wrong, and I let that inform the planning that I do for my estates. So what did I learn from this case? When my client, the person that I'm guiding through the probate process, has an obligation to carry out distributions, I need to, as her counsel, ensure that she does that. In this case, apparently, maybe it's alleged anyway, that did not happen. So ultimately, for me, I'm going to ensure that my clients do what is absolutely necessary to get the property out so that there is not extended litigation beyond the probate proceedings themselves. I mean, that was bad enough. Again, I thought this man had an estate plan. I mean, I read this thing and I was like, they got into some, puffery and all kinds of stuff. Talked about some of his roles. He was in Jackie Robinson in 42, Thurgood Marshall in Marshall, Prince T'Challa in Black Panther. All the royalty rights and all the things. And then, paragraph 2, because the decedent did not live a will. I slapped my knee then. I was upset, and I'm gonna get over it. So again, if you have not planned for your estate, that is one thing you might want to get on, because if you don't, you end up in probate court with the state's default rules. Mr. Warner, what's going on with his case? Well, looking at some of the documents for Mr. Malcolm-Jamal Warner, he was on the opposite end of the spectrum. He had all of the things. He had a trust. That trust was set up, however, in 1996. He got married later, and he entered into a prenuptial agreement with his wife in 2022. There probably was a few things that maybe should have been updated in the trust. I don't know. Again, I can't throw any of those practitioners who drew any of that stuff up for them and say that they did or didn't contemplate it. That's not my business to say. My job here is to tell you what I'm learning from these particularly, salacious and newsworthy events. What's happening here is Miss Warner, she is suing or had sued in Georgia for breach of contract. Essentially, the contract that is supposedly have been breached here was the prenuptial agreement. Ain't that something? Prenuptial agreements or contracts? What is she talking about? I didn't have time to get into the whole thing, but the gist of it is we made an agreement, and I think our agreement should last beyond death. There was a no contest clause in this trust. Doesn't she violate the no contest clause? No. Why? Because no contest clause talk about disputing the terms of the trust. Apparently, she has no problems with the terms of the trust. What she has a problem with is the payments under her prenuptial agreement, and what she's asking the court for is to have those payments made from the trust. Why does the family have a problem with that? Because that reduces what might be left to them. So I said that Malcolm-Jamal Warner had all of the things, a trust, a prenup. So how did things kind of get discombobulated here? Again, there was enough time in between those two documents that maybe they did not refer to one another, and maybe they should have. Some people might be wondering, well, they had all of this stuff and they're still going through all of these problems. Why in the world should I do it for myself? Well, the answer to that is because you want to avoid these problems. You just want to be more careful about how you execute. When we're talking about these particular issues, they are really nuanced. Lots of clients that I meet out in the public, all of them give me little this and that's and do-it-yourself reasons for why they don't need the assistance of an attorney to help them with this stuff, but I can almost guarantee that that is going to end you up with lots of attorneys involved in your family situation, and those documents that you thought were going to be private, they end up public. What can I learn from this particular situation? So if I do a trust for my client many moons ago, first off, I'm going to ask my clients to come in at least once every 2 or 3 years so we can have what I call a relevance review. What does that even mean? We should see whether the provisions that we put down on paper 2 or 3 years ago are relevant to your lifestyle today. If nothing needs to be changed, no problem. We don't change anything. If something needs to be changed, no problem. We just change it. In any event, it's better to look and update those documents on a regular and ongoing basis. What did I just say? I said, when you do your trust, you ain't done. Just think about the situation where you put a trust together when you've got really small children. In that particular trust, along with the associated documents, you'll name guardians for children. What happens when those children turn age 18? Do they need guardians? Nope. Does that document need to be updated? Probably. Definitely. I think that's probably what's going on here. There was two documents done really far apart in time, and ultimately that gave the opportunity for some things to be misinterpreted or some room for some spaghetti to be thrown up against the wall. And I think the thing that gets this in the newspaper more often than not is the fact that the parties involved happen to be Mr. Warner's mom, who was the successor trustee under his trust, and his wife. Now, isn't that the common thing? Whenever I put my trust together for my clients and they start to tell me who they want to serve in different roles, one of the things that I'm always on the lookout for is whether the role that my client is putting the parties, the respective parties in, could potentially cause conflict. And so if Mr. Warner had contemplated that particular issue, maybe when he did his update from the 1996 version of his trust to the, I don't know, 2020, 2021, 2023 version of his trust, he could have said, wait a minute, I'm not getting ready to get my mama tied up in all of this anymore. She's gotten many years older at that point, and maybe she just don't want to be bothered with this stuff anymore. And so that would have given him the opportunity to kind of rectify that. I don't think it would have been as salacious and a news story if this were a professional trustee that his widow was suing for the enforcement under that contract. I think also that trust would have been updated. You guys might be wondering, how does he know so much about what's going on with these particular cases? Well, let me clue you in. Courts are public venues. Anybody with fingers can find documents. What do I mean by that? I just had to go and figure out what courts are these being handled in. And what did I find out? I found out that Mr. Malcolm-Jamal Warner had two cases, one in Los Angeles County Superior Court, the Probate Division, and another in DeKalb County Superior Court. You go to those particular websites and you just look up names. And what names would you look up? In Mr. Malcolm-Jamal Warner's case, I looked up his spouse's name. Why? Because she is the petitioner. So if you want to check all of the stuff that I just got through talking about, that's all you got to do is go out there and check it out. And the same happens to be true for Mr. Chadwick Boseman. I was sorely disappointed to figure out after going and getting those documents that he didn't have no will. Hey, y'all folks out there who knows celebrities and you know they don't have a will, send them over here. I'll get them hooked up if they just happen to be in Tennessee, Texas, or Michigan. And if you wish to keep your stuff private, you got to do it right and make sure that it doesn't end up in public courts, because once it's there, everybody, lottie-dottie, everybody, even me, can see it. While we're here talking about Chadwick Boseman and Malcolm-Jamal Warner, I just want to have you understand that this is very, very, very common. It is the reason why states have default rules. Why does the state make up your will if everybody has one? It's because everybody doesn't have one. The statistics are that about 56% of U.S. adults do not have any estate planning documents. That's a big number. Only about 24% have a will, and only about 13% have trust. This stuff is not for rich people. These problems are not just for rich people. These problems are for everyone. The people that end up in my office, I tell them very often that they're not here for themselves. Well then, who are they there for, Charles? Glad you asked. They're here for their loved ones. They're here so that their loved ones don't have to clean up the mess left from failure to plan. Because when you don't make a plan, you're planning to fail. And so ultimately, we like to encourage everybody to get your affairs in order, because every one of us, one day or the other, will leave this earth. It's just a fact of life. As soon as that thing started ticking, the time clock started ticking to the last one. And one day, it's going to stop. And so you might as well go ahead and prepare for the inevitable, because it will be here one day. We just don't know when. Some of us like to think it's going to be after we've had the opportunity to get gray hair, or in my case, no hair. But in any event, this is a problem that anybody can have and a problem that everybody can solve.